Hey everybody, Jonas Callis of the Hurt at Work Workers' Compensation Law Firm. Many of you know me as the Workers' Comp guy. Today I wanted to talk a little bit about a topic that I think it comes up with pretty much almost every claim, whether it's workers' compensation or just like an automobile accident or something like that. Whenever there's an insurance company involved and or something ends up being headed towards litigation, the issues of a recorded statement is what it's called, and of course depositions are often rear their ugly heads, I guess. So the first way I want to talk about it today, and you'll see why towards the end, but I wanted to talk about recorded statements first and then depositions. Part of the reason for that is that recorded statements happen first and earlier during that process. So soon after an accident, whether it's a workers' compensation, a workplace accident, or just an automobile accident or something that's not even related to work. But of course, in this context, we're going to be talking about workers' comp stuff. So soon after a work accident, information about the accident will be, whatever information is available, will be forwarded to the insurance company's workers' compensation insurance claims adjuster for her or his review. The insurance claims adjuster obviously works for, well, either the insurance company or sometimes insurance companies actually will kind of contract that work out to people who are more familiar with the laws in a certain area. So sometimes they'll be like TPAs or third-party administrators who will handle, for example, workers' compensation claims for a variety of insurance companies who provided the workers' compensation insurance. But in any event, the claims adjusters often, whether they work for a TPA or an insurance company, they often perform the same kind of tasks. So the claims adjuster is going to be the person that ultimately decides, based on the information that she or he has collected, whether to accept a workers' compensation claim or to deny the claim, or maybe accept part of it but deny part of it, that kind of thing. Now, in order to make that determination, she or he will gather various types of evidence through various means. Some of this is, one of the things they'll do is discuss the claim with whoever the employer's representative is, right? The person that handles, maybe it's an HR person, personnel that handles workers' compensation issues. They'll talk the claim over with that person, including any kind of witness statements, and believe that they'll get if it's a written witness statement or if it's a verbal recorded witness statement, they'll get copies of those witness statements. So they'll discuss all those things with the employer. They may end up, to the extent they have witness statements but need more clarification, or to the extent that there are no witness statements but witnesses were kind of identified, they may even, the claims adjuster may even interview those witnesses to find out what happened, okay? They will also, to the extent they are available, they will secure all medical records of the injured worker to review and analyze those. They're looking for reporting. They're looking for what kind of injuries are identified and whether the injuries are supposedly related to the work. They're looking for evidence of pre-existing and underlying types of health issues. In the same way that they kind of go after the medical records and try to review those, and this kind of is part of what I mentioned initially. When they're talking to the employer, they want to obtain all the accident reports that were created. Sometimes if it's if you've looked at my website or heard some of the other videos that we have out there, you'll see that some employees obviously are delivery drivers, right? Well, so sometimes they'll be out and about driving around delivering pizza or food or whatever. And a motor vehicle accident, a rear ender or something, a fender bender will happen. And obviously, in a lot of those cases, police officers are involved, and they're called to the scene, and they do their own investigations and write their own reports. And a lot of times there'll be police crash reports or something along those lines. So the adjuster will try to secure all those to get all kinds of statements to gather the information to have before her or him while making this decision. Now, the last part of this is typically last or close to last, after they've already gathered a bunch of other information, is to actually contact the injured worker and request a time and date for discussing the claim. They want to discuss the accidents, the injuries, et cetera, et cetera, et cetera. Some personal information. And this is called the recorded statement, okay? Now, it's important to note that the claims adjuster will use all this information, okay, during the investigation to, in my experience, sometimes they accept the claim, sometimes they do. It's rarer though. It's more likely that they'll deny the claim. And how do they deny it? What do they base it on? The denial. They base the denial on the information that they've gathered during this process, interviewing the employees, talking with the employer representative, and the recorded statement. So, in addition to making that decision of whether a claim is accepted or denied, the insurance claims adjuster will kind of guesstimate, if you will, an amount called the reserve amount, right? Which is the amount that they're estimating based on their experience, based on the medical records, based on whether, the different people's narratives of how the accident occurred, whether maybe it's compensable or not compensable under Virginia law. All those factors they take into account, and they set a dollar amount, which is called the reserves of the claim. Once the reserves are set, it's difficult to convince an insurance claims adjuster to move off of that, especially upward, right? They're always eager to move downward, but they're hesitant to move upwards unless they have some convincing evidence to the contrary that would cause them to do so. Okay, so a recorded statement obviously is very, very important to their investigation of the claim, but also since their investigation directly impacts the injured worker's right or entitlement to benefits, at least in the short term, the recorded statement becomes a very important part of that. And obviously, since the reserves are set based on all that, the recorded statement included, it can also lower the settlement value, at least initially, that the insurance company and the employer are willing to offer the claimant for a full and final settlement of the claim. So, so maybe it helps to go into a little bit more detail as to how the post-accident investigation process works. So after receiving notice of the accident, the adjuster will call the employer in order to attempt to find out what it knows about the accident and maybe any injuries that have allegedly occurred. Depending on the employer, okay, the insurance adjuster may not get a very accurate narrative or account of the accident itself. And this can happen for several reasons. One reason is employers' premiums are based upon how safe or dangerous their employment, to be what it means to be employed with that company. Like, how safe or dangerous is that? If there are a lot of workers' compensation injuries and claims, then their premiums go up. So that's one reason. It's a money reason. It's a business reason. Arguably it shouldn't be, because that's no reason to, I don't want to say lie, but maybe paint things in a different light. It's no reason to. That's not a good reason to do that. But it's in the real world it happens, I think. So that leads to an increase in the tendency of certain employees, certain employers, to misrepresent or misremember facts surrounding an accident, or if nothing else, to instead of just being objective and reporting all the facts, they kind of report their side of the facts, right? Which is not really reporting all the objective facts. So that's one reason why the adjuster may not get an accurate account of the accident. And so obviously what happens? Well, after receiving a less than accurate narrative of how the accident happened, the adjuster has there's a reason right there to deny the claim, okay? And certainly not readily accept the claim, right? If nothing else, they'll say, well, we need to get a recorded statement from the injured worker. So what happens is next, armed with this kind of shaky misinformation from the employer, the insurance claims adjuster will contact the injured worker to set up a date and time to provide the recorded statement. Now, what is the recorded statement? When that date and time comes, it's really a question and answer session with the adjuster guiding the direction of it. Like, she or he's the one that asks the questions and kind of guides the direction. Because think about it. This is what she or he does for a living. Like this, they do this all the time. So they have their little question and answer sheet. They have their template, right, that they go by, and they ask those questions and follow-ups. So, and obviously it's a recorded statement. So that conversation is typically recorded, all right? These adjusters are trained by whatever the topic. So we were talking about workers' compensation, okay? So, I mean, I used to do this, right? Like they would call me and ask me questions. Hey, I have this claim, such and such. They're saying such and such. You know, what's the law in Virginia? Like are there any, what are the catches of the laws in Virginia? Are there any exceptions, things like that? So we'd have a long discussion about how they should approach the recorded statement, what questions they should ask, et cetera, et cetera. So they're trained by specialists, Virginia workers' compensation specialists, as to what questions to ask. So it's not as innocent as it may seem, okay? It sounds innocent, but it's not, because they are, a lot of injured employees who don't know better view it as a chance to kind of tell their side of the story, right? And explain why they're entitled to workers' compensation benefits. But what they don't understand is it's often used instead as a trap by the insurance adjuster and the insurance company to gather evidence that actually will end up being used against the injured worker. All right. So I think that's all I want to say about that for right now. So listen. So why? I mean, take a step back and look at it, and it makes more sense, right? Insurance companies are businesses. They're in it to make money for their shareholders. They actually have a fiduciary duty to make money for their shareholders. They can't go along wasting money. That's how people get in trouble. Okay. Business people, business owners, boards of directors and officers of businesses. So how does an insurance company do that? Well, they do that by collecting premiums, right? And denying as many claims as possible, right? Collecting the money in the form of premiums and denying and declining to pay out that money in insurance benefits, right? So it's the same thing with workers' comp. They want to deny as many claims as they can. And if you think about it, they're really supposed to. So it's kind of set up, unfortunately, to be kind of an adversarial system where people are butting heads against each other. It is what it is. But just keep in mind that it is the goal of every insurance company adjuster to deny your claim and to gather evidence against you, no matter how nice they may seem and how helpful they may be purporting to be, right? Their ultimate goal is to get enough information and to catch you with something, get some piece of information, aha, got you, I'm going to deny this claim now for that reason. So a lot of times the way they do this, they come across as pleasant, nice, and they'll present it as this is merely just I do this all the time. I do it with every claim. It's merely a formality. It's just something that has to happen. I'm just checking off the boxes. This is nothing. Doesn't mean anything one way or the other. Just needs your description of the accident, some general background information. Nice and pleasant, right? And sometimes they'll even kind of present themselves as their role is to help the injured worker and facilitate the process of them getting benefits. I don't know that that's accurate, actually. I'm not sure that's appropriate for them to say that, but sometimes they'll present themselves in that way. So it's something to be aware of. The takeaway from all that I've just said is don't be fooled. They're there to deny your claim. And so as a result, because they know what they're doing, and injured workers often, they haven't been through the process before. They're trained at some other specialized job skill. They don't know necessarily what's going on, what to avoid, what tricks and traps the insurance companies are going to use. So a lot of times just only bad things will come from giving a recorded statement without first at least consulting an attorney. Because they'll believe the insurance adjuster's pitch and they'll just kind of go forward and thinking that they're in the good hands of some good-natured insurance claims adjuster, which is just not the case. So it's not true that being fair and honest will carry the day, that by divulging as much information as possible and talking on and on to the insurance claims adjuster during the recorded statement, it's not true that will carry the day. they're not going to like you anymore. Okay, it's just and I don't know that they dislike. The insurance claims adjusters don't necessarily like or dislike the injured workers. They just have a goal. Their goal is to not get the information needed to deny a claim if it's there. Okay, so don't fall into that trap. Now, I've said it will be used against the injured worker a lot of times, the recorded statements. Well, how does that happen? Okay, well, first, the claims adjuster will compare the recorded statement once it's been given. Okay, compare the recorded statement with other accounts of the accident, right? Accident reports, medical records. Sometimes an injured worker will fill out a form. How'd you get injured, right? Blah, 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 right? And sometimes the doctor will or the physician's assistant will ask when the injured worker is in the room. And sometimes they won't, sometimes they will, but sometimes they'll jot down a little narrative about how the worker got hurt. So the insurance claims adjuster will compare what was said in the recorded statement to these other narratives of how the accident happened. Okay? Now, if you think about this, most of the time discrepancies exist, right? Why? Well, because the supervisor who's taking down the what the injured worker says may not be taking down everything with an eye towards litigation. The doctors certainly don't necessarily take down the injured worker's history with an eye towards litigation. The doctors are worried about getting that patient better, right? They just have a completely different focus. So there often will exist discrepancies in the different narratives that are sitting there before an insurance claims adjuster. All that does is give them reason to deny the claim, okay? Well, there are discrepancies, so somebody's lying somewhere. That's the attitude. Sometimes it's right, but a lot of times it's not. It's just because discrepancies can exist. So another, like I said earlier, because I used to do it, insurance adjusters are trained by specialists in whatever states. You know, I've known some adjusters that handle multiple states, okay? And they have an attorney or multiple attorneys on call, on speed dial practically, on each of those states with regard to workers' compensation issues, right? So they have people they have a little army of people that can advise them on, kind of tricks and traps to use in Virginia, for example, to get out of paying claims or to deny claims, at least initially, all right? And unfortunately, injured workers who aren't trained, who don't have people to advise them, don't even realize it's happening during the recorded statement. They think they're being honest and everything, and things are going well. And meanwhile, the adjuster's sitting over there on the other end, just taking notes and smiling and putting stars beside things. So, a lot of time, and some insurance claims adjusters are nice and pleasant, like we said before, and some of them actually aren't. Some of them are more formal, and some of them are even kind of short and curt, and almost attempt to bully or push the injured worker into certain answers. For example, if they're feeling pressured, some injured workers will kind of be like, "Yeah, I guess so," right? Just to get the adjuster off of their back. Well, I guess so is kind of an admission, right? It's like, yeah, sure, I guess so, whatever. Yeah, I guess that sounds right, right? That's kind of yes, right? It's certainly not a denial, right? So that can come back to haunt injured workers, right? And insurance adjusters know this; they do it all the time, right? So that's something that you have to be wary of. I think, okay, so that's another reason. The next reason, insurance adjusters they're trained to lead injured workers down the path of making statements that may sound like the injured worker remembers less than they actually do remember. Okay, and how do they do this? For example, before they even begin to record the recorded statement, that obviously they're talking on the phone before the recorded statement starts, and they may say something like, "Well, I guess it all happened really fast," or "It probably seemed like a blur," or "You probably were pretty shaken up afterwards," or "Does that make it difficult to remember exactly what happened?" Right? So they kind of plant these seeds, and after that, and while they're doing that, right, the injured worker's thinking, yeah, that's true. And they're kind of thinking, okay, well, that's acceptable then. That's kind of an acceptable, the insurance claims adjuster's heard it before. She's even talking about that. So that's an acceptable answer. I mean, is it, right? Doesn't it make you seem like you can't really remember that much of it? You're kind of making it up on the fly, right? So that's not good either. And so once the injured worker once the insurance claims adjuster has planted the seed, the injured worker will answer that. Sometimes the worker will preface her or his answers with statements like, well, I can't remember for sure. It happened all kind of fast, but I think such and such, right? That's not a very good answer, really. So in a lot of cases. So what happens next? Well, you have this recorded statement here that maybe makes you seem like you didn't recall that much. And the recorded statement was done maybe 2 or 3 months earlier before the hearing or trial. So who remembers what they said in a specific recorded statement, telephone conversation that lasted 20 minutes 3 months ago, right? And what happens is the defendant's attorney will use the recorded statement. Number one, they'll use it actually at depositions, kind of to impeach the credibility, right, of the injured worker. And they'll also use it at trial for the same reason. It's like, well, here you said this. Why are you saying, here you said X. Why are you saying Y now, right? So, and again, what does that do? Well, it undermines the credibility of the injured worker. It makes them look like they can't really remember. They don't remember that well. Well, if you can't remember that well, then your testimony isn't as valuable, right? So that makes any other evidence that may exist, like accident reports that were given and taken at the time of the accident, statements that were made to healthcare providers at the time of the accident, when it's closer to the accident and fresher in their memories, it makes those seem more credible, right? So, and if those are unfavorable, then the injured worker will have an uphill battle trying to get benefits. So should an injured worker give a recorded statement after his or her work injury? Hopefully I have explained the risks associated at this point with agreeing to just voluntarily give a recorded statement to an adjuster after a work injury. It's important, and this is for multiple reasons, right? But primarily it stems from, this is not the injured worker's forte, right? But it is the insurance adjuster's forte. It's what they do, right? And they're trying to trip you up, okay? So, and the thing is, like, so what's the solution then, right? Because here they are, they want a recorded statement, and they're asking the injured worker to set up a time and date to give the recorded statement. Well, so first and foremost, there's no rule, like in a workers' compensation claim. There's no law, no rule, no statute that an injured worker has to agree to give a recorded statement to an insurance claims adjuster in a Virginia workers' compensation claim. So what does that mean? Well, it means they can deny, they can decline. No, I'm good. No thanks. I'm not going to give a recorded statement. So don't feel bad, right? Because injured workers should understand that insurance companies and employers will have a chance. They'll have a chance to depose the injured worker. They have an opportunity to cross-examine the injured worker at the trial or hearing. They'll also have a chance to have the injured worker examined via an independent medical examination, sometimes called an IME. So they have multiple, the employer and its insurance company will have multiple opportunities to examine and cross-examine and et cetera, the injured worker. There's really no reason, no good reason, I think, to give them another free chance. Because this one, if there's no requirement that it happen, then at best it can be said to be voluntary, right? So there's no reason why the injured worker should voluntarily agree to give more free information to the employer and the insurance claims adjuster. And maybe the best way to understand this is if the injured worker's claim has not already been accepted, right, as compensable, right? They got medical records, they have accident reports, they have maybe witness interviews, witness reports. If they, based on all that, if they still haven't accepted your claim, like, they're probably not going to accept it when you give the recorded statement either, right? So if you have a strong case, there's just really not a very good reason to give the recorded statement and to just supply them with, maybe they trip you up with the words that they use or how they ask the question. There's just no reason to give them that opportunity. And that's just giving them additional reasons to deny the claim. Now I say that, and I want to be clear though. The reality of the situation is, if they ask for a recorded statement and the injured worker says, no thanks, I'm opting not to provide a recorded statement at this time, probably they're going to deny your claim for sure, right? I mean, that's probably going to lead to that. Now, that said, like I just said, they're probably going to deny your claim anyway. So they're just trying to get extra evidence before they do it, right? And that extra evidence, hopefully, the reason they're trying to get it is to get something else to use against you, right? So they're probably going to deny it anyway. So them saying, well, we denied it because they didn't give the recorded statement, yeah, maybe. I'm not sure if I believe that. So now, all that said, if the injured worker understands all the risks involved with voluntarily giving a recorded statement and still opts to do so anyway, he or she should know that the recorded statement will proceed roughly as follows. First, the insurance claims adjuster will call the injured worker. They'll have a little brief discussion. Hey, it's such and such. Are you ready to do your recorded statement as we previously had scheduled, et cetera, right? So the first thing is, after that, she'll turn on the recording device. And then once it's recording, she'll again introduce herself for the record, state the date of the phone conversation, the date the employee was injured, the employee's name, state the claim number. Now, this is the claim number that the insurance company has given the claim, right? It's different from the claim number that the Workers' Compensation Commission has given the claim. So there'll be kind of two claim numbers that to deal with. And the last thing, usually the last thing is she will confirm that the injured worker, has given permission to record the conversation. Now, then she'll usually ask, it's just like a standard format, really. Like, she'll ask questions about most or all of the following. Injured worker's height and weight, education, work history, income, marital status, finances, length of employment with the employer, job duties, how you got hurt, what body parts you hurt, who you reported your injury to, when you reported your injury, how you reported your injury, whether there were any safety precautions applicable to the accident, whether you had used any drugs or alcohol within the 24 hours preceding the accident, when you first received medical treatment, where you received medical treatment, what kind of medical treatment, current work status in terms of work restrictions or out of work or full duty, whether the injured worker had already injured the subject body part previously, or had other underlying health conditions related to that body part, whether the injured worker has been involved in any motor vehicle accidents, any other significant accidents, any disciplinary problems with the employer, whether the injured worker has been fired from a job before, for what reasons, what treatment that you have scheduled coming up, medical treatment or physical therapy or whatever. Now, as you can tell, so that's a lot of the questions. That's a lot of the topics, I should say. This seems kind of fairly invasive, right? I mean, a lot of injured workers think so. So why are these questions so invasive? Well, remember, the insurance claims adjuster is looking for a way to deny the claim. That's why they're having this recorded statement. They're not on your side. They might be looking for a pre-existing underlying condition. They may be looking for a failure to timely report the accident and injury to the supervisor. Or they may be just looking for a way out, because remember, not all accidents that happen at work in Virginia are actually compensable workers' compensation accidents. The accident had to arise due to some specific risk of the actual employment. Okay, so maybe they're just looking for the description of the accident to say, hey, you weren't even doing your job at the time of the accident. There's no, that was not work related. So, and another thing, which is, to me, is kind of, I don't particularly care for, but sometimes what they're trying to do is determine the education level of the injured worker and the financial situation of the injured worker, so they can determine whether delaying payment and denying the claim will constitute kind of a hardship on the injured worker, which will possibly lead the injured worker to accept maybe kind of a lowball settlement offer to get rid of the claim. right? Even when they know the claim's valid, right? If they have a reason, what they consider a good faith reason that they could litigate, at a hearing, they'll try to do that to put pressure on the injured worker to maybe have them accept a low settlement offer. But anyway, so that's that part of it. Obviously, you see how I feel about injured workers voluntarily giving recorded statements that they don't have to give to insurance adjusters. But if you understand the risk of giving a recorded statement and want to do it anyway and without first consulting with us, which we don't recommend, the following tips could be helpful to better prepare you for giving the recorded statement. Don't give the adjuster a statement as soon as it's requested, right? At that point, the adjuster's ready. She's got all her questions laid down. She's reviewed it and everything. She's ready. And she'll do it next time too. But don't do it right when she wants to do it. Reschedule it for a later time. That'll give you time to prepare. Review the same materials she's reviewed, right? Get a copy of the accident reports, all of them that you can, and the witness statements, your medical records. Like, review everything. Kind of have that claim familiar in your mind before you agree. And then just agree on a date and time more convenient to you. Second, reconsider your previous decision not to hire an attorney. At a minimum, maybe consult with an attorney, because you may not know what loopholes or catches or tricks or traps that you may be running into with your particular type of accident, like how it happened, or like maybe pre-existing conditions or something like that. That it may be beneficial to consult with an attorney, even if you have to pay some. I have a free consultation policy. Some attorneys pay for it. Or demand payment for a consultation. I have free consultations. It may be worthwhile, right? Especially depending on the seriousness of your injuries, to get kind of an expert opinion before going into the recorded statement. Third, request that the statement be unrecorded instead of recorded, right? Ask the adjuster to just take notes instead of recording the statement. Remember, in Virginia, there's no rule that you have to do it. So you're just being nice. I'm not sure why an injured worker whose claim has been denied wants to be nice, but sometimes they do. So you're being nice. I mean, you certainly don't have to agree to it being recorded. So you can request that it be unrecorded, and you can take notes too, and you can request that she take notes. A lot of times they'll deny that. Okay, they'll decline that, but it's your right to ask. I just know we're talking about workers' compensation claims. If you're filing for some sort of benefits under your own insurance policy, that's an insurance policy is a contract. You may have an obligation to give a recorded statement to the adjuster of your own insurance. That's your own insurance policy. Workers' compensation is not your own insurance policy. It's the company's insurance policy, right? And there's just no obligation on your part. So ask that she unrecord it. Like, don't record it. Take notes. Number 4, after you've reviewed all the accident reports, photos, videos, medical records, maybe talk to witnesses. If you don't have witness statements and you know them, call them up, right? Call them up, tell them what they remember, how they would testify if asked, because it looks like it's going to litigation and you're just kind of curious. Remember, your goal during the recorded statement, so you're ready at that point, right? But your goal is not to just talk forever, right? It's not to get out the whole story of everything you studied and let them know that you've been studying or anything like that. Your goal is just to answer any questions that they ask. Answer them, don't be cute, don't be too cute, but answer them. Answer them and answer them succinctly. Don't ramble on. Don't volunteer information. And again, this should be an unrecorded statement, I feel like. Number 5, if at all possible, have a witness present during the unrecorded statement when you're speaking with the insurance claims adjuster. Number 6, during the unrecorded statement, take notes as to being what's asked and said. Number 7, during the unrecorded statement, speak slowly and clearly. Number 8, during the unrecorded statement, answer only the questions asked and do not ramble on. Number 9, during the unrecorded statement, do not make off-the-cuff comments or jokes. It's not the place for it. It's a business thing, really, at least from their perspective it is. Number 10, during the recorded statement, do not volunteer information that you haven't been asked about. Make them ask. And if they don't ask, that's tough luck. That's what she gets paid to do. If she doesn't do it, that's her problem, not yours. 11, during the unrecorded statement, do not explain unless asked to. That kind of goes with the volunteering. If they ask you to explain, explain. If you have chosen to do it, to give the recorded statement, Number 12, during the unrecorded statement, do not answer questions that you do not understand. Just ask them to repeat or rephrase the question, because you don't want to answer a question wrong because you misunderstood the question if it's kind of a vague or ambiguous question. Be your own best advocate, right? If something's unclear, or ask them to rephrase it or repeat it or ask it in a different way. Number 13, during the unrecorded statement, do not guess, do not assume. Again, ask them to repeat or phrase anything that's unclear. And to the extent numbers are involved, times, dates, distances, amounts, speeds, whatever, right? Just tell them you can't answer because you have to guess. You weren't clocking anything, right? Relatedly, with regard to estimates, that's kind of like an estimate. If for whatever reason you feel the need to estimate, I would say don't estimate. Just say it would require me to estimate. If you need to estimate, make sure you make that clear. I have no idea. I would estimate between such and such and such and such, right? Like, let them know you're estimating, though, right? During the unrecorded statement, do not feel like you have to know or remember things. Tell the adjuster you're unsure. It's okay to say, I don't know. I can't remember. I can't recall at this time. Whatever. It's okay. You don't have to know everything. No one knows everything, and no one can recall everything. It's okay to not know it. I don't know. I don't recall. It's an okay answer. If you do know, don't lie and say you don't know. But if you don't know, don't guess, right? And we talked about this a little bit. Number 15, I think it is, maybe, or something. During the unrecorded statement, do not let the adjuster bully you into an answer. Don't let them pressure you. If you don't know, you don't know. Already talked about 16, about don't estimate. Or if you do estimate, make sure you make it clear that you're estimating. 17, during the unrecorded statement, do not use words that have an absolute meaning, like always or never. It's just bad. Basically, those things are never true. So just don't use. I just said never, but you know what I mean. 18, during the unrecorded statement, do not easily admit that you did anything wrong. Remember, oftentimes, especially the farther you get out from an accident, right? But oftentimes, even close to the accident, your memory can remember things in a certain way. That's why you have people who, in a traffic accident case, you have a bunch of people saying the light was green. No, I think it was yellow. No, I think it was red. I'm pretty sure it was red, right? Everybody who saw it, they have different recollections. So don't be so ready to admit your wrongdoing. I mean, the other thing is, if you're in pain after the accident, like that also can mess with your memory and how your perception of things, right? Because you're kind of worried about your pain, your ankle or your knee or whatever, right? I'm not telling anybody to lie. Certainly don't lie, okay? But also just don't admit to something that you don't know to be true. 19, during the unrecorded statement, ask for a copy of the unrecorded, or of the, I think it should be unrecorded if you volunteer to do it at all, which I don't think you should do. But, if you're given a recorded statement, if you disagree with me and you give a recorded statement, ask for a copy of the transcript of the recorded statement. Sometimes when they copy, the insurance company, the claims adjuster, when they're recording something, when they type it up, they'll mistype it. They'll mishear something, okay? You want to be able to review that statement for accuracy and say, that's not accurate. That's not what I said. Or if it is, it's not what I meant to say. I meant to say this. And lastly, I would say do not sign anything unless you have, I would recommend a qualified attorney review it before you sign anything. Now, the next thing I want to discuss really quickly, make your own recording of the recorded statement, okay? If they can record it, so can you, especially since it's just a voluntary thing anyway. You're just agreeing to it, which I don't recommend. You have every right to deny it, okay? But if you choose to give it, you're giving it, they're wanting to record it, you can record it too if you want, right? If you record it, you'll have that statement, the questions they ask and your precise answers when you're preparing for your deposition, when you're preparing for someone else's deposition maybe, when you're preparing for trial and what you think other witnesses might say. You'll have your copy of the recorded statement, okay? And there are a lot of, obviously, it's 2020. There are a lot of free programs online. There are a lot of apps that you can do that. You can even do it with an old-fashioned tape recorder if need be. One thing, though, if you're going to do that, tell the adjuster up front that you're recording the conversation. I understand you're recording it. I'm also recording this for you, so you know. Okay, you need to tell them up front that you're doing it. Now, and like I said, if you do give a recorded statement under Virginia law, Section 8.01-417, you are entitled to a copy of the recorded statement, to the transcript of the statement, if you request it. So that's important. Now, I know that's a lot, but I think there's a lot of information in that if you kind of rewind it and go over it again and take some notes. But that's all I wanted to cover about recorded statements today. And I know it's a lot, okay? But I think it's all important because it's you can shoot yourselves in the foot big time. Now, here's the good news about the next topic, which is depositions. Remember earlier I said we're talking about recorded statements. We're going to talk about depositions. Talking about recorded statements first because they happen first and then depositions later. 99% of what I just said about recorded statements are also true about depositions. Okay, it's basically it's a question and answer session. Okay, except depositions will be conducted by an attorney instead of the insurance claims adjuster, right? And the deposition will be taken under oath. You'll be sworn in, right, to give honest testimony. You should be giving honest testimony anyway to the claims adjuster and anywhere. You should be honest. You should be an honest person. But so it'll be taken under oath. It'll be transcribed by a court reporter, so you really won't have any need to record it yourself. Somebody who's like a certified court reporter or whatever will listen and type down the conversation. They get things wrong sometimes too, though, so you want to review that after the fact, once they've typed it up, maybe in a week. But aside from that, one more I'm going to talk about, but basically the same topics. Everything I talked about with the recorded statement, it's like the same topics, and you can prepare for it the same way as you would a recorded statement, right? That you can treat the deposition in very similar manner, okay? Just know those differences, those small differences. And so here's the last difference. I said recorded statements are voluntary. There's nothing in the Virginia law that requires you to record a statement. You don't have to do it. You can decline to do it, right? That's all true. That's not true about depositions. If you've reviewed our website and seen our other videos, deposition is one of several discovery tools that are officially, parties can use to gain information about the claim. Okay, so you may decline to give a recorded statement to an adjuster, but you cannot simply opt out of a deposition. Okay, if and when requested by the attorney for the employer and its workers' compensation company, pursuant to Rule 1.8 of the Rules of the Commission, they have a right to investigate the claim by deposing you. All right. If you receive a notice of deposition, you can't simply ignore it, right? Because that could lead to like dismissal of your claim or something like that. Now you may be able to, depending on if it was unilaterally scheduled by them, you may be able to reschedule it to a time that's more convenient, but you can't just not do it. Okay. So that's the last part, and that's important though. I don't want to set anybody up for failure. You have to do a deposition, but I've given you all the tools to prepare and to know what they're going to ask and to prepare answers and kind of look over the thing to prepare for it, to do a great job at the deposition. Okay, so that's all I wanted to discuss about recorded statements and depositions. Thanks for watching my video. I hope it's been helpful. For more information, check out our website and our YouTube videos. The website is www.hurtatworkinva.com. That's www.hurtatworkinva.com. It's chock full of information to help injured workers get their bearings on their claim and do their best. And here's the thing. If you found this helpful, the information, the website, the videos, then probably other people would find it helpful too. So tell your family, tell your friends, get the word out, right? It's better to have this information and not need it than to need the information and not have it, right? They may be going through a similar thing that you're going through. They may know someone who's going through a similar thing that you're going through. So get the word out. I'm hoping to help people with this information. I think it's good information. This is what I do for a living. I hope it's good information because otherwise I'm bad at it, and I'm not bad at it. So that's all I got. Until next time, stay safe and don't get hurt at work.